Paper, Law and Citizenship Education. Section A, Introduction to Law and Fundamental Rights. 20 marks. Question 1, examine 5 fundamental principles guiding the administration of justice in Cameroon. Answer. 5 fundamental principles guiding the administration of justice in Cameroon include: 1. Independence of the judiciary. The judiciary in Cameroon is constitutionally guaranteed independence from the executive and legislative branches. This ensures that judges can make decisions impartially, without fear of interference, pressure, or undue influence from political powers or other vested interests. This principle is crucial for upholding the rule of law and safeguarding citizens' rights. 2. Presumption of innocence. Every person accused of a crime is presumed innocent until proven guilty according to law. This principle places the burden of proof on the prosecution, requiring them to establish guilt beyond a reasonable doubt. It ensures that no one is punished without due process and a fair trial, protecting individuals from arbitrary detention or conviction. 3. Right to a fair trial. Due process. This encompasses several aspects, including the right to be heard, the right to legal representation, including state-provided counsel for indigent persons in serious cases, the right to confront witnesses, the right to present evidence, and the right to an unbiased and impartial hearing within a reasonable time. It ensures that judicial proceedings are conducted justly and equitably. 4. Equality before the law. This principle asserts that all individuals are equal before the law and are entitled without any discrimination to equal protection of the law. No one is above the law, and legal processes should apply equally to all citizens, regardless of their social status, economic standing, gender, religion, or ethnicity. 5. Right to appeal. Individuals have the right to have their case reviewed by a higher court if they believe there was a legal error or injustice in the initial judgment. This provides a mechanism for correcting judicial errors and ensures that justice is ultimately served, contributing to the credibility and fairness of the judicial system. Section B. Civics, Ethics, Moral, and Citizenship Education. 20 marks. Question 2, critically examine 5 different methods for the acquisition of Cameroonian nationality. Answer. 5 different methods for the acquisition of Cameroonian nationality are: 1. By filiation, jus sanguinis, right of blood. Description: this is the most common method. A child acquires Cameroonian nationality if at least one of their parents is a Cameroonian national at the time of their birth, regardless of the child's place of birth. It can be through the father or the mother. Examination: this method reinforces national identity based on lineage and is a cornerstone of family law. It ensures that children of Cameroonian parents born abroad retain their national link. However, it can lead to statelessness if the country of birth does not grant citizenship by jus soli, right of soil, and neither parent is a national of that country. 2. By birth on Cameroonian territory, jus soli, right of soil, with conditions. Description: while Cameroon's nationality law primarily favors jus sanguinis, a child born in Cameroon to foreign parents can acquire Cameroonian nationality under specific conditions. For instance, a child born in Cameroon to stateless parents, or to foreign parents whose nationality laws do not allow the child to acquire their parents' nationality, may acquire Cameroonian nationality. Additionally, an infant found in Cameroon whose parents are unknown is presumed to be Cameroonian by birth. Examination: this method serves to prevent statelessness and acknowledges a connection to the territory. It is a limited application of jus soli compared to countries like the United States, reflecting Cameroon's preference for bloodline transmission. 3. By marriage, naturalization through marriage. Description: a foreign national who marries a Cameroonian national can apply for Cameroonian nationality after a certain period of marriage, usually 5 years, and residence in Cameroon, provided the marriage is valid and subsisting, and the applicant demonstrates good conduct and sufficient assimilation into Cameroonian society. Examination: this method facilitates family unity and integration. It acknowledges the bond created by marriage. However, it is not automatic, it requires a formal application and fulfillment of specific conditions, including a period of stable marriage and demonstrated integration, to prevent marriages of convenience solely for citizenship purposes. 4. By naturalization, grant of nationality by decree. Description: a foreign national who has lawfully resided in Cameroon for a specified continuous period, generally 10 years, though exceptions exist for those who have rendered exceptional services to the state, can apply for naturalization. The applicant must be of good moral character, demonstrate sufficient knowledge of one of Cameroon's official languages, English or French, possess adequate means of subsistence, and show a genuine intention to reside in Cameroon. The granting of naturalization is discretionary and by decree of the President of the Republic. Examination: this is a discretionary power of the state, allowing it to integrate individuals who have contributed to or integrated into Cameroonian society. It allows for the selective granting of citizenship based on various criteria. The discretionary nature means there is no absolute right to naturalization, and the process can be lengthy and challenging. 5. By reintegration, reacquisition of nationality. Description: a person who has lost Cameroonian nationality, example by voluntarily acquiring a foreign nationality, though dual nationality is generally not recognized for adults in Cameroon unless acquired by birth elsewhere, may apply for reintegration. This process typically involves demonstrating a genuine desire to re-establish ties with Cameroon and may require fulfilling certain conditions similar to naturalization. Examination: this method provides a pathway for former nationals to regain their citizenship, recognizing their original link to the country. It is important for individuals who might have lost their nationality due to past legal provisions or circumstances and now wish to re-establish their full legal connection with Cameroon. Section C. Labor Law, 20 marks. Question 3. Briefly explain the reciprocal duties of parties engaged in a labor contract. Answer. In a labor, or employment, contract, both the employer and the employee have reciprocal duties, meaning that each party owes obligations to the other. These duties are essential for the proper functioning of the employment relationship and are generally implied by law, even if not explicitly written in the contract. Duties of the employer. 1. Duty to pay remuneration. The employer's primary duty is to pay the agreed upon wages or salary to the employee for the work performed, in accordance with the terms of the contract and relevant labor laws. This includes timely payment and adherence to minimum wage requirements. 2. Duty to provide work. While not always absolute, the employer generally has a duty to provide work for the employee to do, especially in cases where the employee's remuneration depends on actual work done, example piece rate work, or where the employee needs to maintain or develop skills. 3. Duty to provide a safe working environment. Employers are legally obligated to ensure a safe and healthy workplace, taking reasonable steps to prevent accidents, injuries, and occupational diseases. This includes providing necessary safety equipment, training, and maintaining safe machinery and premises. 4. Duty to treat employees with respect and fairness. This encompasses duties such as not discriminating against employees, providing fair disciplinary procedures, and generally acting in a way that preserves the dignity and well-being of the employee. 5. Duty to reimburse expenses. If an employee incurs expenses on behalf of the employer in the course of their duties, the employer generally has a duty to reimburse those legitimate expenses. 6. Duty to provide tools/equipment. If applicable depending on the nature of the work, the employer may have a duty to provide the necessary tools, equipment, or resources for the employee to perform their job effectively. Duties of the employee. 1. Duty to render service. Perform work. The employee's fundamental duty is to perform the work or services agreed upon in the contract, diligently and to the best of their ability. This includes adhering to working hours and fulfilling job responsibilities. 2. Duty of obedience. Employees are generally required to obey lawful and reasonable instructions. given by the employer within the scope of their employment. This does not extend to illegal or unsafe instructions. 3. Duty of loyalty and fidelity. Employees owe a duty of loyalty to their employer. This includes not working for a competitor, not disclosing confidential information or trade secrets, and generally acting in the best interests of the employer during the course of employment. 4. Duty of care and skill. Employees must exercise reasonable care and skill in performing their duties, considering the nature of the work and their qualifications. Gross negligence or incompetence can be a breach of this duty. 5. Duty to account for property. Employees have a duty to account for any property, money, or assets of the employer that come into their possession during the course of their employment. 6. Duty to maintain confidentiality. Employees are often obligated to keep confidential information related to the employer's business secret, both during and sometimes even after the employment relationship. Section D. Business Law, 20 marks. Question 4. Certain characteristics are peculiar to insurance contracts which are not found in ordinary contract law. Assess the veracity of this statement. Answer. Assessing the veracity of the statement, certain characteristics are peculiar to insurance contracts which are not found in ordinary contract law. The statement is veracious, true. While insurance contracts are fundamentally a type of contract and thus incorporate general principles of contract law, example offer, acceptance, consideration, intention to create legal relations, capacity, legality, they possess several distinct characteristics that differentiate them from ordinary commercial contracts. These peculiar features arise from the unique nature of insurance, which involves managing risk and uncertainty. Here are some key characteristics peculiar to insurance contracts. 1. Utmost good faith, uberrimi fide. Peculiar to insurance, this is perhaps the most distinctive feature. In ordinary contracts, parties are generally expected to act in good faith, but they are not obliged to disclose every material fact. In insurance contracts, however, both the insurer and the insured are under a strict duty to disclose all material facts known to them, whether asked or not. A material fact is one that would influence a prudent insurer's decision regarding whether to accept the risk and on what terms, example premium, conditions. Impact. Failure to disclose material facts, non-disclosure, or misrepresentation can render the contract voidable at the insurer's option, even if unintentional. This high standard of honesty is necessary because the insurer relies heavily on the information provided by the insured to assess risk. 2. Insurable interest. Peculiar to insurance, the insured must have an insurable interest in the subject matter of the insurance. This means the insured stands in such a relationship with the subject matter that they would suffer a financial loss if the insured event occurs, or gain a financial benefit if it does not occur. Without insurable interest, the contract is considered a wager and is void. Impact. This characteristic ensures that insurance is a contract of indemnity, or payment upon a specified event, in life insurance, and not a gambling agreement. For example, you cannot insure your neighbor's house unless you have a financial interest in it. 3. Indemnity. Peculiar to insurance, for most non-life policies, most non-life insurance contracts, example property, liability, are contracts of indemnity. This means the insurer undertakes to put the insured in the same financial position they were in immediately before the loss occurred, without allowing the insured to profit from the loss. Impact. The insured can only recover the actual amount of their loss, up to the sum insured. This prevents moral hazard, where an insured might intentionally cause a loss to gain financially. Life insurance, however, is generally not a contract of indemnity as life cannot be valued financially. 4. Subrogation. Peculiar to insurance, related to indemnity. After the insurer has indemnified the insured for a loss, the insurer acquires the rights of the insured to recover compensation from any third party responsible for the loss. Impact. This prevents the insured from recovering twice for the same loss, once from the insurer and once from the third party, and reinforces the principle of indemnity. It also ensures that the party ultimately responsible for the loss bears the cost. 5. Contribution. Peculiar to insurance, if an insured has taken out multiple policies with different insurers for the same risk, and a loss occurs, the insured cannot claim the full loss from each insurer. Instead, each insurer is liable to contribute proportionately to the loss. Impact. This principle, like subrogation, prevents the insured from profiting from a loss and is based on the principle of indemnity. 6. Proximate cause. Peculiar to insurance, in insurance law, for a claim to be valid, the loss must be directly caused by an insured peril, and the immediate or dominant cause, the proximate cause, must be determined. Intervening causes are often examined. Impact. This principle helps to determine whether a loss falls within the scope of the policy coverage and to avoid paying for losses that were not truly a result of the insured risk. Conclusion. While sharing fundamental contractual elements, insurance contracts clearly possess unique characteristics such as iberami fide, insurable interest, indemnity, subrogation, and contribution. These features are necessitated by the probabilistic nature of risk and the need to prevent moral hazard and ensure fairness between the parties. Therefore, the statement that certain characteristics are peculiar to insurance contracts which are not found in ordinary contract law is entirely accurate. Section E. Company Law, 20 marks. Question 5. Examine the discrepancies that exist between public limited companies and private limited companies as provided for by the AHETA law. Answer. Under the AHETA Uniform Act on Commercial Companies and Economic Interest Groups, Uniform Act relating to commercial companies and economic interest groups, OTCI, significant discrepancies exist between public limited companies, Sociétés Anonymes, SA, and private limited companies, Sociétés à responsabilité limitée, SARL, primarily concerning their formation, governance, capital requirements, and ability to raise capital from the public. Here are key discrepancies. 1. Minimum capital requirement. Public limited company, SA requires a higher minimum share capital. As per AHETA law, the minimum capital for an SA is typically XOF 10 million CFA francs. This substantial capital requirement is due to their public nature and ability to raise funds from a wider investor base. Private limited company, SARL has a much lower and more flexible minimum capital requirement. The minimum capital for an SARL is generally XOF 1 million CFA francs. This lower threshold makes it more accessible for small and medium-sized enterprises. 2. Ability to raise capital from the public offering. Public limited company, SA explicitly designed to raise capital from the public through the issuance of shares or debentures, either upon formation or subsequently. Their shares can be listed on a stock exchange. Private limited company, SARL is prohibited from making public offerings of shares or debentures. Its capital is raised privately among its members. This restriction limits its access to large-scale public financing. 3. Number of shareholders/members. Public limited company, SA requires a minimum of 1 shareholder, single shareholder SA is permitted, and generally has no maximum limit, facilitating wide ownership. Private limited company, SARL requires a minimum of 1 member, single member SARL is permitted, and typically has a maximum limit on the number of members, example generally 100 members under AHETA law, though this can vary slightly by specific national legislation adopting AHETA. This limitation is to maintain its private character. 4. Governance structure and management. Public limited company, SA has a more complex and formalized governance structure. It typically requires a board of directors, conseil d'administration, and can also opt for a 2-tier system with a supervisory board and management board. The management structure is highly regulated with specific roles and responsibilities defined by law. A statutory auditor, commissaire auxiliary comptes, is mandatory. Private limited company, SARL has a simpler and more flexible management structure. It is managed by one or more managers, gerents, who can be members or third parties. The appointment and powers of managers are less strictly regulated than those of an S.A.S. directors. A statutory auditor is only mandatory if certain size thresholds, turnover, balance sheet total, number of employees, are met. 5. Transferability of shares/parts. Public limited company, SA shares are generally freely transferable, making it easier for investors to buy and sell their ownership interests, especially if listed on a stock exchange. Private limited company, SARL shares, known as parts sociales rather than actions, are generally not freely transferable to third parties. Their transfer often requires the approval of a majority of the existing members, reflecting the intuitu personae, personal relationship, nature of private companies. 6. Publicity requirements and transparency. Public limited company, SA subject to more stringent disclosure and publicity requirements due to its public nature and impact on a wider range of stakeholders. This includes more extensive financial reporting and public filing of documents. Private limited company, SARL subject to fewer disclosure requirements, reflecting its private character and fewer stakeholders. In conclusion, AHATA law clearly differentiates between public limited companies, SA, and private limited companies, SARL, based on their intended purpose, capital raising capabilities, governance complexity, and regulatory oversight. The SA is designed for large-scale enterprises requiring significant capital from the public, while the SARL is suited for smaller, often family-owned, or closely held businesses.